Mr Chairman, I would like to respond to the members' tabled amendments because they have been presented with some thought and consideration, and they are genuine amendments, and I certainly acknowledge that. First of all, I'll take it from the last one, which was the issue about tenants having advocates before the Tenancy Tribunal. It might be worth informing the House and those listening and the member that in fact I can give 6 ways in which a tenant can get advocates, which may or may not be legal counsel, to assist them at the Tenancy Tribunal, so they're at no way disadvantaged. The first way they can have an advocate is if they go and ask the other party, the landlord, consent. So if a landlord consents that the tenant has an advocate, then the tenant can have an advocate. There's another way. If the dispute exceeds a sum under this new legislation of $6,000, so if we're talking about $6,000 or more being in dispute, then the tenant can certainly have an advocate, in fact, can have legal counsel. If the landlord is represented by an advocate or by legal counsel, then again, that's the third way that a tenant can be represented by an advocate or legal counsel. Fourthly, if the nature of the issue at stake is quite complex, then the Tenancy Tribunal can allow the tenant to have an advocate and may be represented by counsel. So if it is a complex issue, the tenant can certainly have an advocate. If there is significant disparity between the two parties, so if the tenant, the disparity between the tenant's knowledge or ability to defend themselves and the landlord's ability and knowledge to defend themselves is so great, there's such a large disparity, then the tenant most certainly can have an advocate. We talk about this in the sort of David and Goliath situation. If the tenant is indeed vulnerable and in a David situation, they can have an advocate. If the person is a minor, so a very young person, or has a disability, then absolutely they can be represented by someone approved by the Tenancy Tribunal. So if it's a young person or someone with a disability, they can have a representative appointed to help them. And then sixthly, the last way is the tribunal itself, if it's satisfied that for some other reason, apart from the David and Goliath situation, the complexity of the issue, where the other party's got legal advocacy, or whatever the other 5 reasons are, the Tenancy Tribunal, even if none of those reasons are fulfilled, the Tenancy Tribunal can still rule in favour of the tenant having an advocate. So there is no shortage of avenues for a tenant to have an advocate, and that's why we don't believe it's worthwhile supporting the amendment that the member Moana Maki puts up, although I acknowledge that it is a serious issue, and I appreciate the fact that she did bring it forward. The other issue she brought out was regarding the issue of tenant liability for damage, where the Labour Party would like to shorten or reduce the liability for damage accidentally caused by a tenant or by a tenant's guest by the value of 4 weeks' rent. And we're opposing this SOP as well, because limiting the liability for damage would impose unfair costs on the landlord who did not cause the damage, was not the one who allowed the tenant's guest into the house to cause the damage, and the landlord was not there when the tenant accidentally caused the damage themselves. So why would a landlord, the owner of the property, why should they get stuck for the fix-up bill for damage caused by a tenant or their guests? We believe in personal responsibility, and we believe that it's important that tenants meet their obligations in this regard, just as we would expect, and certainly this legislation makes sure that landlords, where they are to fix properties and keep them in a decent state of repair, should do so as soon as possible, which of course, as one of the previous members said, is one of my challenges, or Housing New Zealand's challenges in one of the in Pomeri, in Hutt Valley. Mr Speaker, there's also the issue over the Rugby World Cup, because Moana Maki is rightly concerned about those that were during Sevens competition who were asked by owners of, Mr Speaker, owners of the property to vacate so that they could have in-residence visitors from overseas and from within New Zealand to have accommodation and pay quite high fees for that accommodation while living in Wellington. And Wainamaki's concerned that that might happen with other national sporting events, particularly the Rugby World Cup. And my challenge is to the Labour Party and the member is, in that case, if she's concerned about it, to vote for this legislation. Because the reason why landlords were previously able to do that in Wellington is they only had to give 24 hours notice for someone to move out. Well, this legislation, which hopefully the Labour Party will support today, makes it that they have to give 28 days notice before someone leaves the accommodation. So landlords are going to be very reluctant, and certainly boarding house operators are going to be very reluctant to ask someone to leave 28 days in advance of a sporting event, because they may very well get 27 days of no rent. So we think it's important to support this legislation to fix that problem of people with short notice being asked to leave, in order that overseas tourists can take up their positions in that accommodation and pay a much higher rent, because this legislation will now require landlords, boarding house operators, to in fact give 28 days notice, not 24 hours notice. And had that been in place when the Wellington Sevens event was on, I don't think you would see as many people at all asked to leave the premises that they were living in order to make room for those travelling with deep pockets from overseas.